Hello, my name is Eva Bailey and I'm a partner in the family law team at Anderson's Solicitors. This is Troy Roulstone and he's a senior associate in our family law team. We're here to talk to you today about the merger of our Federal Circuit Court and the Family Court of Australia. It's fair to say, I think, that the profession has been somewhat against this merger for some time. I think that's right, isn't it, Troy?
It's a pretty fair assessment, I'd say, Eva. Throughout the process, the lawyers involved in family law have had a number of serious concerns about this proposed merger, and I'm just going to run through a couple of the most serious ones now. Firstly, there's a question as to whether or not this proposed merger is simply a cost-cutting exercise by the federal government, and therefore whether it's going to lead to increased and better services for parties going through very difficult family law disputes. Secondly, the two-tiered court approach has been preferred because it does clearly delineate between the more superior court, which deals with the more complex matters and the appeals issues. Finally, there has been very significant concerns about the lack of investigations into the impact this proposed merger is going to have on victims of family violence and domestic violence. The Attorney General's Department in December of 2020 confirmed at an inquiry that there had been no studies done in relation to what this court merger is going to mean for parties who have been victims of domestic and family violence. There's been no consultation with children's services, with children's advocate groups or children's special interest groups, and there hasn't been a working group formed with the Office for Women about what this merger is going to mean for those parties. And ultimately, those are some pretty serious shortcomings about this proposed merger.
Yes, I agree, Troy, and those are the reasons why the profession has had many concerns. One of those concerns primarily has just been the need for additional funding for our family court system, and that's been something that the lawyers have been asking for a long time. What the government tells us is that this merger is designed to move matters through the family court system more quickly and efficiently with better outcomes for people, and we certainly do hope that's true. We're all about having better outcomes for our clients. It should be said that when the bill was being passed through the Senate, there were promises made by the government about that, about having additional judges and registrars involved in the system to achieve those kind of quicker and better outcomes. Also, this week, I noted that the federal government's budget that was announced also confirmed that there would be additional funding for our family law system. So that's really important, and we're hoping that that is what it leads to.
Yeah, that's a very good way to describe where we're currently at. I just want to sort of turn very briefly to the history of how this has developed. Ultimately, the bill passed the Senate last year in December. It's passed the House of Representatives in February of this year, but it's not actually coming into effect until the 1st of September this year, meaning that we presently still have two different courts. We have the Federal Circuit Court of Australia and the Family Court of Australia, but as of the 1st of September, that merger becomes official and we will have one court at that time.
So as of September then, Troy, we will have a Federal Circuit Court and Family Court of Australia Act, and that Act, its objects are, and I'm going to read directly, to ensure justice is delivered effectively and efficiently, to provide for just outcomes, in particular for family law or child support proceedings, and to provide a framework to facilitate cooperation between the two divisions of the Federal Court and the Family Court of Australia with the aim of ensuring common rules of court and forms, common practices and procedures, and common approaches to case management. There will also be two divisions of the court, Division 1 and Division 2. So what does all of this mean, Troy?
The practical impact of the bill that has now passed is, as you've said, we'll have one court with two divisions. The court is going to be called the Federal Circuit and Family Court of Australia. Division 1 of that court is going to be the existing Family Court of Australia, which deals with the more complex matters and the appeals. Division 2 of that court is going to be the existing Federal Circuit Court of Australia, which deals with the general federal law matters, as well as family law matters and child support issues. The practical impact for lawyers is going to be that we will have to now only file in Division 2 of that court, and matters can only be elevated to Division 1 if it's approved by the Chief Justice. So presently we can file in either of those courts. That's going to end as of the 1st of September.
Okay, so there'll be one point at which we file proceedings into that particular court, and there'll also be one set of rules and one set of court forms, which I've got to say, Troy, I think that's going to be a lot easier for us lawyers. At the moment, depending on which court you file, you have a different set of rules and a different set of court forms.
It will be much simpler for us now having only one set of rules that we need to rely on. One set of forms will be much more helpful as well. But the question still is, Eva, what's going to happen with our appeal matters?
As I understand it, all judges in Division 1 of the court will be able to hear appeals from any court in Division 1, courts in Division 2, and any state court that has made a decision in relation to family law matters. So, in conclusion, it is hoped by the government that the merging of the two courts and the harmonising of rules and forms and case management will lead to better and more expedient outcomes for people through the family court system.
Regardless of the profession's previous positions on this proposed merger, if the merger is positive for our clients, and that is the matter can proceed more cost effectively, faster, and with better facilities for our clients, then the profession will be on board with those changes.
And that's certainly what we try to do here for our clients at Andersons, and we're happy to see that merger go through if it means that for our clients. Thank you for listening to our presentation.